All right, we are rocking and rolling. Classes. Objections generally fall into one of four classes: evidence rule violations, procedural rule violations, general law violations, validity, and precedence. We'll examine each of these in general and later describe in detail several of the common objections you are likely to encounter when you go to court. Evidence rule violations. These are the most frequently heard objections you'll encounter. Each arise when a party or the judge ignores one of the evidence rules. For example, the objection: hearsay. In an evidence rule violation, there are many exceptions to the hearsay rule covered in other parts of our step-by-step course, and you need to know what they are. However, testimony as to statements made out of court by someone who is not in court and offered to prove the truth of what they said is inadmissible hearsay because the evidence rules forbid it. So, we jump to our feet and pronounce objection. Hearsay. Competence is another evidence rule objection. As stated previously, the only witness who are competent to testify to a fact are those who saw, heard, felt, tasted, or smelled the fact personally. The only competent witness to a fact are those who have first-hand knowledge of the fact, and only those having first-hand knowledge. Otherwise, we jump to our feet. Objection, Your Honor. Competence. The more common of these are included in the text that follows this chapter. In general, to be able to use the evidence rule objection effectively, you need to know the theories behind the evidence code, i.e., why we have the various rules and how each rule meets the needs of justice. Then when you see a violation of an evidence rule, it will become second nature to object. You'll object quickly and promptly, state the grounds for your objection, get and study our materials on understanding evidence rules. We'll go over that in a later video. Procedural rule violation. These two are quite common. Anytime a party or a judge permits an action that is not permitted by the rules of civil procedure, or the rules of criminal procedure in a criminal case, an objection should be promptly made, identifying the rule and how it is being violated. For example, suppose a party moves the court for an order setting the case for trial before all motions directed to the pleadings have been disposed of. In all jurisdictions we know of, a case is never ready for trial until all motions directed to the pleading, such as a motion to strike a sham complaint, are disposed of. A motion to strike a sham complaint is directed to a pleading, i.e., the complaint. Therefore, the case is not ready for a trial if such a motion is pending and has therefore not been yet ruled upon. The motion is directed to a pleading, and so the case is not ready for trial. Other examples of a motion directed to the pleadings are motions to dismiss or to require a more definite statement. Such motions directed to the pleadings must be ruled upon before a case is ripe for trial. If the opposition moves the court for an order setting your case for trial, or the judge on his own motion sets your case for trial before a motion to dismiss, motion to strike, or motion for more definite statements have been ruled upon, or in some courts before discovery is completed by both sides, object at once. If the court sustains your objection, trial will be delayed until the requirements of the rules are met. If the court overrules your objection or refuses to rule on it, you have grounds for appeal if it turns out that going forward to trial materially prejudiced your case. Such objections relate to violations of the rules of procedure. To understand more, you need to study our complete lawsuit self-help course, where you will find it easy to learn about motions, discovery, and procedures that win lawsuits. General laws violations. These arise less frequently. However, it should be clear that if a party or judge violates an ordinance, statute, appellate court decision, or other prospective law, an objection should be made at once, stating the law that's been violated and, if necessary, describing how it's been violated so the court record will reflect what's happened and the judge has an opportunity to cure the problem. For example, in many states, if a party resists producing documents on the grounds that the documents contain trade secrets and the requesting party moves the court to do so, the judge must examine the documents in camera, which means in chamber, all right, i.e. private, outside of the view of the requesting party. Then enter an order finding the documents do contain trade secrets that should be protected, or declaring they do not contain trade secrets, and ordering them to turned over to the requesting party. This happens a lot when you're dealing with bankruptcies and you're doing like a class 10 series broker, and you're subpoenaing them to the court. There are trade secrets that they will not talk about, such as the QSIP number, the off-balance ledger sheet, and books. They're forbidden from talking about it, and the judge will absolutely help them because they don't have to testify to trade secrets, okay? So a class series 10 broker can literally sit on the bench and lie out his ass about the double bookkeeping entries, the off book ledger sheet, the QSIP number, how much all that's valued at, because it's trade secret. It's not going to be revealed in the court, okay? There's other ways of going about that. But for today, we're just going to focus on what's in the criteria here. This is the law in many states. The judge's failure to abide by the law is objectionable error. It is not a rule of procedure nor a rule of evidence. It is general law that controls the court. Similarly, though an extremely unlikely example, if the opposing party brings a loaded shotgun to the court, the basis for your objection is that general law forbids anyone other than the judge and bailiffs and other law enforcement officers to possess firearms in the courthouse. Any violation of general law is objectionable error. Polity, and it's P-O-L-I-T-Y, not sure I'm pronouncing it right, polity, and precedence violations. The objection in this classification are based on common sense and decency. For example, suppose your opponent walk into the court with a 300-pound gorilla on a leash. You may confidently object. You may find a 300-pound gorilla in a black robe sitting on the bench, but it is a violation of polity and precedent for wild animals to be admitted to the court unless good cause founded on a necessity can be shown. Failure to object, however, and you won't be permitted to complain on appeal. Suppose the other side requires a seeing eye dog. You might object, but in all likelihood, your objection would be overruled. Polity and precedent are established in such cases. Seeing eye dogs are allowed in most courts because it is the right thing. It is probably not a good idea to show up in court wearing cut-off jeans and a Grateful Dead t-shirt either, because polity, P-O-L-I-T-Y, and precedent don't allow it. Our courts are controlled by more than rules of evidence, rules of procedure, and general laws. They are controlled also by public policy, a reasonable code of decency, and the requirement of polite decorum. Failure to object, however, may defeat later complaints to an appellate court that you lost because someone was wearing shorts or was allowed to bring their pet canary to court. If it doesn't seem proper, object and make your record. Such objections are rare but valid nonetheless when disruptions of proper and polite proceedings prejudice your ability to effectively present your case. Do not let the court become a three-ring circus without objecting and getting the court to rule on your objection. I just think that's funny, the three-ring circus, because I once hammered a prosecuting attorney and his fleas and his three-ring circus and the fact that he was a barnyard pimp for the judge, and I objected to everything that he did, and I just find it funny when they say the three-ring circus, because that's basically what I accused him of. Now knowing what I know, I would have hammered him for Barratray, extortion, Hobbs violations, but anyway, let's move on. In particular, make your objection clear if you are not allowed to have a court reporter present for all proceedings to prepare a written record of all that's said, so you may later obtain a transcript for any possible appeal without being required to obtain the judge's permission. If there is no record of a hearing or trial, or the judge denies your right to have a transcript made so you can submit it to the appellate court, and this is an important subject matter, ladies and gentlemen, always, always, always have a court reporter and a stenographer in the room, and use your own recording devices so you can make a true and accurate transcript of what is being said, okay? There can be no appeal in the event some error by the judge causes you to lose. Failure to have a court reporter present in a persistent cause of lost cases that should have been won. Courtrooms should be managed by the judge in a manner that promotes order and a level playing field for both sides in the dispute. For the judge to allow anything that disrupts this balance is appealable error. If the disruption adversely affects your case, indeed, if it appears to you that anything is being allowed that adversely affects your right to a fair trial, object, no matter what grounds you may have. When we come back, we're going to be doing the asked and answered part of this. I'm just going to keep these videos nice and short for you guys.